Good afternoon, everybody. Welcome to another Webinar Wednesday. This is Justin Philman with Local Government Academy. Thank you so much for joining us this Wednesday afternoon. We're joined in the studio today with our friends from Campbell, Durrant, Beatty, Palombo, and Miller. We have Shon with us today. We're going to be discussing labor and employment law. Trust me, it's a lot more interesting than it sounds, so stick with us. If you have any questions, feel free to use the chat feature here on YouTube. That requires you to sign into your Google account and maybe create a YouTube channel. That's something that we're fixing. Promise that that's one of the things that we'll be fixing in the very near future for these webinars. And if you can't get in through there, just send us an email to info@localgovernmentacademy.org. I'll be monitoring that while Shon's giving his presentation, and I'll pass any questions to him along at the end. If you're unfamiliar with LGA, we are a tiny but mighty nonprofit, nonpartisan, non-advocating organization. We handle education and training events for local government officials in the southwestern PA area. Those do include in-person and online sessions like this, plus online classes. We're working on all that. We also have internships. Right now, I think we have 24 interns out in the region right now that are doing work for their local municipalities. We also help provide technical assistance for Act 47 and EIP communities. If you're familiar with either of those terms, then you know why we do that. And we also help to facilitate grants whenever those opportunities present themselves. So stay tuned to that. If you are subscribed to our newsletter, then you already know about these upcoming events that we have, but I do want to run through them quickly so you know what's on the calendar for us. Wednesday, August 8th, we have a collaboration with the Sustainable Community Development Network from Sustainable Pittsburgh, as well as our friends at Connect. We're going to be working with Pennsylvania 811 on coordinating road construction and repair with utility companies. So tune in for that, add it to your calendar, sign up today. Also, the very next day, Thursday, August 9th, is our annual recognition luncheon. That's LGA's opportunity to thank all of our sponsors, donors, and instructors for the year. Good time to meet the interns that are out there and see the projects they've been working on this summer. So if you haven't already received your invitation and RSVP'd, hurry up and do that because there's only a few seats left. And if you haven't gotten an invitation, go ahead and onto our website and get more information about that. On September 12th, we will have Dan Cohen back here in the studio to do negotiating cable franchise services with confidence. So make sure you join us for that if you can. And the big Managing Marcellus event, that's going to be the Beaver County Economic Development Symposium. We're doing that Tuesday, September 18th. That's going to be an all-day event. There will be lunch served, and there'll be a great opportunity to talk about all the development surrounding the natural gas extraction here in the region. So it's our collaboration with Washington and Jefferson College and the Center for Energy Policy and Management. Make sure you join us for that. We'll definitely be sending more information about that as the date approaches. So mark your calendar. That's a get out of work free card there. And another webinar we have coming up in September with Gateway Engineers, strategic planning for long-term budgeting. That's going to be Wednesday, September 19th. Again, Gateway Engineers, they're our go-to source for all things infrastructure, so make sure you join us for that. All right, and now here we are with our friends Campbell, Durrant, Beatty, and Palombo and Miller. We have Shon K. Warner, Esquire, here. Shon is our go-to person for all things labor and employment, and he's here for an hour to share all of his information with you, and he'll answer any of your questions. So again, type them in the chat feature or send me an email. And without further ado, here is Shon.
Thank you, Justin. It was a very nice introduction. I appreciate that. So we're here today to talk a little bit about issues with respect to labor and employment law. Many of you may already know, and if you don't, I'm here to tell you today that unfortunately public employers are in litigation much more often than private employers, and a big part of the reason for that is that public employees actually have more rights in the employment realm than private employees do. And in order for us to avoid liability in labor and employment matters, one must know what can cause that. So we're going to talk a little bit about that as we go through the presentation today. Unfortunately, lawsuits are a fact of life. They're a fact of life for those in business. They're a fact of life, particularly for those who are in local government. And what we're going to talk about today is where we see most often some of those issues arise. Federal litigation is one of those areas. As you may know, litigation can occur both under state and federal law. what we often see in the public sector is litigation occurring under federal statutes. Some of the theories under which people bring claims against municipalities and elected officials include Title VII. You guys may have heard of Title VII and what that protects. That's basically the primary employment discrimination statute that protects against discrimination in all facets of employment on the basis of race, color, creed, sex, national origin, etc. There are other anti-discrimination laws that you may well have heard of. One of those, of course, is the Americans with Disabilities Act that protects individuals who have disabilities, as that term is defined under the law, and we're going to talk about that a little bit more later. It also protects, the laws also protect age discrimination. The magic age for purposes of the age discrimination statute is 40. I happen to be in that group, and I can tell you I don't feel very old, but I am protected under the law, and so is anyone else who is 40 or over. A couple other laws that often come up, the FMLA, many of you may have heard of or actually even used FMLA leave. FMLA stands for Family and Medical Leave Act. That's a law that, depending upon the size of the employer, the number of employees that it has, mandates up to 12 weeks of unpaid leave due to various either serious health conditions or the serious health conditions of a family member or for the birth or adoption of a child. It also mandates up to 26 weeks of service member leave. So that's another law that we often see litigation occurring with regard to public sector entities. And the last one that I want to touch on is actually the second bullet point here on this slide, and that is it's generally referred to as Section 1983. It's a federal law that protects the rights that are granted to employees by other federal statutes and, importantly, by the United States Constitution, because, of course, as a local government, especially as a local government employer, you have to be mindful of the fact that you are the government. So, therefore, any actions that you take with respect to your employees necessarily implicate constitutional principles, and we're going to talk more about that here in a minute. So what are some common types of Section 1983 claims? One of the most common ones that we see are due process violations. And we're going to talk more about this here in a bit as well. But essentially, if an employee has a property interest in their employment, so for instance, if they are subject to a collective bargaining agreement, they have certain rights not only under the terms of their contract, but also because they have a contract for employment with a public entity, local government. They also have constitutional rights, which mandate that they be provided at least a minimum amount of due process before they are disciplined, fired, demoted, suspended without pay. And you may have heard the term a Loudermill meeting. That's something that is a constitutional guarantee for these individuals where they are accorded a certain amount of due process, which means basically that you have to tell them what you think they did wrong and allow them to tell you their side of the story before you discipline them in a way that would deprive them of employment, such as a termination, or of pay, such as an unpaid suspension or a demotion. Other types of claims that arise under Section 1983 include First Amendment claims. Certainly this is an area where it's much different for public sector employees than it is private employees. Employees of private businesses don't have First Amendment rights in the same way that employees do who are employees of local municipalities. And what that means is that if an employee is speaking out on an issue of public concern, so an example that I often use because this is taken out of a case is where a coworker maybe makes a complaint that one of their coworkers is illegally getting or paying themselves overtime pay. Obviously, that's a matter of public concern because it's creating fraud on the municipality and someone is getting something to which they're not otherwise entitled. So that could potentially be an area where if someone made such a complaint, and then if they were fired, demoted, disciplined because of that, they could perhaps raise a First Amendment claim saying, hey, I have this First Amendment right to speak out on matters of public concern. You've detrimentally impacted my employment because of it. Therefore, I'm going to sue you under a First Amendment analysis under Section 1983. That's one area. Now, that right is not unlimited, and you should know this because you may hear an employee say, well, I have rights, I have First Amendment rights. That's true, they do, we all do, but they're not unlimited, and they're not unlimited in the employment context. So if someone is, rather than making a complaint about alleged fraud, maybe they're saying, you know what, John just got this promotion, and I'm really not happy about that. I don't think he should have been promoted. I think I should have been promoted. That is not speaking out on a matter of public concern. That is something that is of a purely personal nature. It's an opinion that the person holds. It's not protected. That would not be protected under the First Amendment. So it is, a complicated area. It's an area that is very fact-specific, but it is also something that, given the course subject matter that we're talking about today, we thought it was important to bring to your attention. Another area, and we're going to touch more on this later, is freedom of association. So in other words, if someone is disciplined, demoted, terminated due to their political beliefs or whether they supported a particular candidate, those are areas that the courts have also deemed to be protected depending upon the employee and their position and what they do. And as I said, we will touch more on that here in a bit. So other types of claims under Section 1983, they include whistleblower type claims. I mentioned before the scenario where someone might allege fraud or waste or wrongdoing on behalf of the local municipality. That could constitute a whistleblower type of claim. The claim itself doesn't have to be legitimate for it to be protected. It just has to have been made in good faith. So that's something to be aware of when you're dealing with your employees. Violation of the Establishment Clause. The Establishment Clause is a provision in the Constitution that protects against a governmental endorsement of religion. So if you have, say, a chief of police who is trying to hold his officers or her officers to a certain Christian standard or Muslim standard, or take your pick, it doesn't really matter what the particular religious belief system is, but it's just mandating some type of religious belief system and is doing that in a way that causes others to be harmed because of it, that certainly could create liability for the municipality. Other areas that we often see are Fourth Amendment and Eighth Amendment claims. These come in under a deliberate indifference type of scenario where someone might allege that maybe a police officer who engaged in some type of activity was not properly trained by the municipality. That's an area of potential liability for a local government. Also, of course, in this, if anyone's ever watched any TV shows that have police officers in them, illegal searches and seizures. Someone does a car stop, they don't have a really good reason for stopping the car, and they end up searching the car and they find, maybe drugs or an instrument of crime. That's always an issue as to whether that stop was legitimate and whether the search that was undertaken was done in a way that's compliant with the law and the Constitution. And if it's not, again, that can create an area of potential liability. So these are some of the areas that we most often see. What's the repercussion? I think it's helpful. I'm not going over these to scare anybody. I've gone through similar types of presentations before with other groups, and they've came up to me afterwards and said, my goodness, it seems like it's a minefield out there. You've scared us. And that's not my intention. To me, I think knowledge is power. Knowledge will help you navigate your way through some of these potential risks and pitfalls. And included in that is knowing, where the problems lie and what the potential repercussions are for not working through those issues in a delicate way. So some of the damages that can arise under some of these claims include several things. One is injunctive relief or equitable relief. And what that basically means is, say you terminate somebody and it's determined by the court to have been for an inappropriate reason. Well, the court could, depending upon the law under which that person is suing you, could mandate that that person be returned to their position. Or if they say maybe were passed over for a promotion and someone else was promoted, they can mandate that that person be put into that promotional position. That's one of the areas that these laws allow redress if someone is successful. Other areas include out-of-pocket losses. So again, if someone's terminated and it's determined to be for an inappropriate reason, one of the things that they could get is back pay. So back pay would be pay for the position that they were working, including all benefits. So that would include healthcare costs, that would include pension contributions, etc. For the time, from the time that they were terminated until the time of the court judgment, which of course could be several years later. It could be a very pricey matter. Other things that are available in terms of damages include attorney's fees. Sometimes that can be a very substantial expense. I know I've handled cases here in the Pittsburgh area. My firm also has an office in Philadelphia where some of the legal fees can be even higher. I know in the Pittsburgh area, some of the more experienced employment attorneys on the plaintiff side have been approved by the courts at a rate of $500 an hour. So if they're successful, not only might the employer have to pay any damages, the back pay, etc., that we just talked about, but also attorney's fees for the prevailing plaintiff, which can be literally in the hundreds of thousands of dollars. When you consider several years of time at a $500 an hour clip, it adds up very quickly. Punitive damages, I want to speak on that just briefly. Generally, some of you may know this, generally punitive damages cannot lie. In other words, you can't get punitive damages against a municipal entity. The primary reason that the courts have stated this is because it is a tax-funded institution. That is a major difference between a private sector company and a public sector entity like a local government. However, there is a potential loophole that plaintiffs often try to exploit, and that is not only will they often sue the municipality, but they will also, if they can, sue the elected officials or employees individually. So they'll sue them both in their official capacity and in their individual capacity. And if a court rules that an individual was acting outside the scope of their employment or the role that they play, so if they're acting in a willful or malicious way, the court could rule that that individual might be subject to punitive damages. The problem with that is it's not an insurable cost. So, most municipalities do carry employment practice liability coverage. If you don't, I would highly recommend that you run to a broker as soon as we're done with this and talk to them about getting it, which would provide at least some modicum of protection against lawsuits, which unfortunately do occur. But punitive damages are not an insurable cost. So not only is it something that you would not want to face just as a general proposition, but the fact that your insurance carrier would not pay a punitive damage, I think, just highlights why knowing what not to do, training your people on what not to do, training people in your expectations, why these issues are so important. So we've talked a little bit about federal claims. There are also state claims that can be brought. And the reason why that's important is for several reasons. One is those state laws, they may apply sometimes in instances where a federal law does not. So say a federal law only applies to employers that have 15 or 20 or more people. Well, not every municipality is large enough to employ that many people. However, there is a state law that might apply to you if you only have 4 employees. So of course, there's that overlap. The other reason why that's important, I wanted to talk about a little bit this Political Subdivision Tort Claims Act. If you haven't heard of that, what it is basically a law in Pennsylvania that says that local governmental entities, certainly any municipality is included in that, many authorities, there are other types of institutions, school districts, some colleges or community colleges might be included. They can only be sued under state law claims to the extent that the legislature has allowed that to happen. And there are 8 exceptions to this immunity. Basically what this law provides is immunity to municipalities, elected officials, and certain employees of those municipalities. And what it does is it protects them when they're acting in the course of their employment. We're going to talk about that here for a few slides. Basically, what that means is if you're doing the things that are expected of you, you're following the policies of your employer, or if you're an elected official, you're acting in the way that is generally recognized to be reasonable for your position, then you generally will be protected under this law against suits so that you personally don't have to shell out money to defend. So in other words, you don't have to pay an attorney yourself. One of the benefits of this law is that it says that if you're acting within the scope of the office or duties, then the municipality will provide defense for the lawsuit that you're facing. And that's true of elected officials and also certain employees who might be sued. So obviously it's a very substantial benefit for those who seek to be in local government. But I will note, it's not a license to engage in bad action, because there are exceptions. Of course, that's a very lawyerly thing to say, right? There's exceptions to almost every exception. And unfortunately, that's often true. And here it's true where if an elected official or an employee is acting outside the scope of their employment, so in other words, if they're doing things that you wouldn't expect them to do or that are contrary to policy, and a judge rules that they were doing that, then these protections do not apply. One of the other major protections of this Political Subdivision Tort Claims Act for state law claims, not only is it the fact that a defense will be provided for you at the cost to the municipality, but also if there's a judgment against you or against the municipality, it will be borne by the municipality, and again, not by the individual personally. So again, this is a strong protection for those who are acting in a way that you would reasonably expect, knowing that they can work for a local municipality. Even if they're sued, they're not going to have to pay for a lawyer, and they're not going to have to pay for any judgment if one comes about, provided again that they're acting in the way that we expect. This last section that I wanted to touch on does talk about the personal liability. So what that says, and this is the caveat, the be aware, if a court determines that someone is acting in a way that either constitutes a crime, fraud, they're acting with malice, or willful misconduct. So in other words, they're acting in a way that is willfully trying to create a problem, then the immunity does not apply. So the cost of defense and the payment of any damages would not apply to that individual. So obviously this is a very strong incentive to be a good boy or girl, to not act in a way that is outside the scope of what is expected. One of the areas where this was found to not apply, just to give you a concrete example from a case, and this is from, and I don't know if we have anyone from Lower Merion here on the webinar, but it's actually from the Lower Merion School District, where the school district officials knew that there had been numerous sexual harassment allegations made against a certain coach. This coach, to my understanding, was a very successful coach. The school was very concerned about the hit on its reputation that it would face if it addressed this and it became public, so they did the worst thing that they could possibly do, and that was nothing. Swept it under the rug. It eventually was determined to have been found out, and it was determined to have actually been happening. And it was also determined by a court that the school officials had known that this was happening and had failed to do anything about it. And in that instance, the Political Subdivision Tort Claims Act was held to not apply. So the liability on behalf of those individuals who were responsible for taking action was theirs. It was not the municipalities or the school districts in this instance, because they had acted outside the scope of what you would normally expect. We know sexual harassment is a bad thing. We know that if we get a complaint, we're going to talk about this here in a bit, we have to do something about it, and we have to do something that is meaningful, and our failure to do so can result in liability. So that's one example of where the Political Subdivision Tort Claims Act was found to not apply to a local governmental agency. So those are kind of the, there's the federal and the state dichotomy. Sometimes they're very similar, sometimes they're different. What we now want to turn to is to talk about what we kind of call the deadly sins of employment liability. And we roughly base this off the 7 deadly sins. And we're going to talk about each of these, but basically what we've grouped them into are the following. One is sloth, and what we mean by sloth, or how we're identifying that, is perpetuating poor supervision practices. We're going to talk about what that means, what you should do to avoid claims under this type of theory. Pride, what we mean by pride is knowing it all, or assuming that you know it all, and then acting appropriately without actually doing an investigation. Envy, what we're referring to by that is failing to account for and prevent employee misconduct. The others are wrath. With respect to wrath, what we're referring to is making employment decisions when you're angry. Obviously, that can be a big no-no. We'll talk about why that's true. Lust, I just touched on a case that dealt with sexual harassment. We're going to talk a little bit more about that. Gluttony, misunderstanding actual versus perceived medical conditions. We know, and I touched on this earlier, that the Americans with Disabilities Act is a very important law. It's one that comes into play very regularly in today's workplace, and it can create a lot of areas of liability for an employer. So understanding how that happens is very important. And then lastly, greed. And what we mean by greed is pay practices, overtime issues, exemption versus non-exemption under the Fair Labor Standards Act. What does that mean? How can it create problems for local governments? We're going to talk a bit about that. So the first one that I mentioned is sloth. And as I indicated, that has to do with perpetuating poor supervision practices. Liability for municipalities, and we found this to be true, is often proportionate to the quality and competence of the managers and supervisors who are employed by that municipality. And, in order to know whether you have a good supervisor or a bad supervisor, you have to know what are some principles that we believe exhibit poor supervision practices. Some of those include the following. They are inconsistency. You will hear from labor attorney or employment attorneys like me or my colleagues that consistency in the employment realm generally is key. There's one exception, and we're going to talk about that in a bit, and that is under the Americans with Disabilities Act. But generally speaking, you want to apply policies that you have, standard operating procedures, practices, whatever the case might be, uniformly to your employees. And when you fail to do that, it creates a question as to whether you're showing favoritism or whether you're being inconsistent for some other reason, especially if you're coming down harder on some people than others. Is it a group of people? Does it happen to be you're coming down harder on women than you are men, or perhaps some minority group versus Caucasians? Those are the questions that often arise when that happens. So poor supervisors are inconsistent, they show favoritism, they don't communicate well. Obviously, that communication is not only on the back end after something happens, but it's also on the front end. Have you communicated your expectations clearly to your employees? If you haven't, how do you expect to hold them to any standard of conduct? Again, that's where we see this becoming a problem. Are they holding their employees accountable? This is very important. There are a lot of books written about what constitutes a good supervisor and what constitutes a good manager. This also often comes up in the context of doing performance evaluations. I've heard this time and time again from clients. They'll call me and say, you know what, I've got this terrible employee. They've been doing things wrongly and badly for months, and I'm ready to fire them. And I say, okay, let's talk about this. I want to hear what they're doing. I want to hear why you think, they're maybe not suited for employment with you. What's in their background? What's in their employment personnel history? What's in their file? What does their performance evaluation say? And sometimes that'll come back and it will be glowing, or it will have absolutely no reference to the fact that someone has actually been doing things that you don't like. That creates a problem. It creates a problem for me because it makes it very difficult for me to talk to my client about doing something when on paper it appears to be a stellar employee. It makes it even more difficult, and this is the most important part, for that employer who's dealing with this employee, because my advice generally is, look, if we have this evidence, unless they've done something very recently since that came out, that creates a very large hurdle to get over when trying to deal with that in a definitive fashion. So it's very important to hold your employees accountable, do it in a timely fashion. If they're engaging in misconduct, let them know that you don't like what they're doing and deal with it right then. Don't hold it. Don't keep a notebook in your desk and never talk to them about it. That's not helpful. You need to hold your employees accountable. And this dovetails, I think, with that next bullet, and that is ignoring employee misconduct. That doesn't help you in any way. Yes, sometimes maybe that's the easier course for that supervisor, but ultimately, failure to address a problem in one area is going to create problems in others, or it's just going to cause that problem to balloon into a bigger issue. So these are all things that I think exhibit poor supervision and which can lead to liability for a public employer. You've heard this before, I'm sure, if not from me, from other people. It's important to have written policies, and that's important for a number of reasons. It's important because general risk management principles dictate having written policies provides some source of protection for an employer. Now, that's true if several things happen. One, it has to have been disseminated. So if you have an employee handbook or you have employment policies, one of the things that's often important is, one, of course, keeping that up to date. Secondly, making sure that everybody has received it. We're going to talk in a minute about documentation, which means signing an acknowledgement that they've received it, that they've understood it, that they've had the chance to ask questions about it, etc. But that policy has no value if it's not disseminated. So that's one thing that's very important. It's also important, and we do this regularly for our clients, provide training. Make sure that your people know. You might have a 25-year employee who you have no concern about knowing that they know what they're supposed to be doing. But invariably, you're also going to have maybe a 6-month employee or a brand new employee, or maybe even a 5-year employee who isn't doing what you expect. So you need to provide training to all of your employees about your policies so that you can say, look, we've taken affirmative steps to inform you of what our expectations are. It has no value if it's not followed, if it's not aware, if the employees are not aware of it. This last one under this particular deadly sin is documentation. So we've talked about informing your employees, about training your employees, about enforcing the policies that you have and being consistent in your enforcement. One of the things we always recommend when we're asked to either draft an employee handbook or to update an employee handbook or to draft certain policies is make sure you have an acknowledgement. And that includes a couple of things. One, that's an acknowledgement of the fact that they've actually received your policies. When you do the training that we're suggesting, have a sign-up sheet. Keep those sign-up sheets. Note who's not there, who's absent. And if they're absent, try to create an alternative for them to come on another day. Those are very important. They can be very useful. I've used them numerous times in, say, unemployment compensation hearings where someone has said, well, I had no idea that I was supposed to not take a lunch during this time. Well, here's your acknowledgement that says that you received the lunchtime policy. So is this your signature? Yes, it is. Well, so how are you now claiming that you weren't aware? That can be very helpful. Same is true in any EOC investigation or certainly in litigation if you get there. I hope you don't, but if you were to get to litigation, these types of documents are very valuable. Also, have you held your employees accountable? It's appropriate, depending upon the incursion, to have a supervisor pull an employee aside and talk to them about what they perceive they're doing wrong. If that's maybe a minor thing, or maybe it's the first time that it's happened, and the supervisor feels in their judgment that that's the best way to handle it. But generally speaking, what I often advise is there are no verbal warnings. And what I mean by that is, even if you have a progressive disciplinary track, and I will note that obviously if you have a collective bargaining agreement with any of your groups of employees, which I'm sure many of you do, you have to follow your collective bargaining agreement. Regardless of what I'm telling you here, you always have to follow your agreement and what it specifically says. But my point is, even a quote-unquote verbal warning, which is often the first step in a progressive disciplinary track, should be memorialized in some way. So you can send a letter saying on this date, we had a discussion, I gave you a verbal warning relating to X, Y, and Z. Then the next one might be a written warning if that continues, and you go up from there. That way you create a record that you can use that shows a couple things. One, it shows you've actually tried to address the behavior that you're not desiring to occur. Secondly, it shows from a progressive disciplinary track that you're actually engaging in that process. You're moving up that step. This last point is, if the supervisor is not, quote, doing discipline, end quote, that is a problem. That's a problem for your workforce, and actually it's a problem for your supervisor. There are no, and I know this is probably hard to believe, but there are no perfect employees. And that doesn't mean that every employee should have a disciplinary matter in their record. What I mean by that is, if you have a supervisor who's supervising a group of employees and they've never engaged in any type of disciplinary action, then that supervisor is probably not living up to what you would expect them to do, because their job is to manage others and make sure that they are following the requirements of the employer. So again, where we often see this is in the performance evaluations. My advice generally is, don't do a performance evaluation if you can't guarantee that your supervisors are going to fill those out and do them accurately, because then they create a problem that you wouldn't otherwise have to get around. So the next deadly sin that we want to talk a little bit about is pride. And really what we're referring to here is, knowing it all or assuming that you know what's going on without doing an investigation. We know that doing an investigation is very important when allegations of misconduct arise. It's important because, one, it's legally mandated. So if you get a complaint of sexual harassment, going back to the Lower Merion School District case that I mentioned before, if you do nothing, that will ultimately, if it's pressed, result in liability for you. It's clear that municipalities have a legal duty to investigate claims of misconduct, and if they find that there was wrongdoing, to take some type of corrective action that stops that conduct from occurring. Not only is that legally required, your residents are requiring this. Think about today's news environment. We have a 24/7 news cycle. It seems like every day there's almost some allegation of wrongdoing in some local municipality. Oftentimes it's centered around your police officers. You'll see here that I have this bullet point that says residents demand allegations be investigated, especially against police. I am certainly not anti-police. I believe that they do a very important service for our municipalities, and by and large they do that very well, and they're very upstanding people. However, this is an area where municipalities suffer much litigation and potential liability because of the mere virtue of the job that they do. They are there to enforce your laws. They have the authority under state law and under your own local municipal ordinances to arrest people. So, by virtue of their position, they often are lightning rods for allegations of wrongdoing. So, anytime you receive allegations of wrongdoing, you need to engage in investigation on these matters. I've dealt with just recently allegations of police officers sexually harassing other officers or engaging in text messages that were what I would consider to be highly offensive, racially charged comments. As I said, not only is it legally required that you investigate these, but think about it from this perspective. The next time, if you don't do anything, the next time that officer has to arrest a female at 2 in the morning when it's, perhaps the person's under the influence, or they get into an altercation with someone who is a minority, and it's found out that you knew that there were these issues in their background, and there wasn't any corrective action taken, or there wasn't any action taken at all, that can create a real problem for you. So these are areas of liability that you can avoid by following up on taking the allegations seriously, doing your investigation, getting all of your facts, and once you have your facts, taking action if it's merited. Now, it's not always going to be merited, but at least you will be operating from a position of knowledge rather than from a position of assuming what occurred. The last bullet point that I notice here is have skilled investigators help. If you believe that someone engaged in conduct and you're not suited to, one, either do the investigation, or two, you have concerns about it because maybe there's some criminal charges involved and you don't know how to navigate that, get help. We often help our clients navigate through this, whether that means that we do it ourselves at the municipality's behest, or we help guide them through literally every step of the way. There are people out there who can help you do that. And by, I think getting them involved on the front end, you do yourself a service in helping yourself avoid liability down the road. Okay, the next one that we want to talk about is envy. What this one, as I mentioned before, this has to do with failing to account for and hopefully prevent employee misconduct, especially as it relates to workplace safety. One of the questions that we often ask is, do you have safety policies in place for your employees? And one of the areas that we often see, and this is particularly pertinent in today's world, is do you have a distracted driving policy? Cell phones are pervasive. Have you talked with your employees? Have you put out a policy about how they can, or if they can, use cell phones while they're operating your equipment or driving your vehicles? What about wearing seatbelts? What about eating while driving? What about if they're tired and they need to stop and take a rest? Do you have a policy that touches on these things? If you don't, I would highly suggest that you do that. Of course, part of having the policy is training them, telling them, this is our policy, this is what our expectation is, here's what the proper protocol is. These are very important risk management tools. Also, and it's unfortunate, but in today's world, we know that workplace violence is an increasingly common occurrence. Do you have a workplace violence policy? If you don't, I would suggest that you consider putting one in place and getting some help to do that if you're not prepared to do it. One thing that the workplace violence policy should do is it should identify what constitutes workplace violence. Does it include threats? Does it include merely verbal communications? Does it include electronic communications? What about people who maybe aren't employed by your local municipality, but maybe what about vendors who come in or third parties who come in and might interact with your employees? Does it cover them? What about bullying? What about hazing? What does bullying and hazing mean? I've seen a lot of different scenarios come to play that arguably fall under workplace violence policy. So, I think it's important to have a policy in place so that you can address it if you get an allegation that it occurs. Also, is your building secure? Depending upon where you're located, particularly if you're located, say, in an area that's adjacent to a district magistrate or maybe in a courthouse, I know a lot of those areas now have a means of checking for weapons. You have to walk through maybe a metal detector. If you don't have that ability or it's a prohibitive cost, what are you doing to ensure that access to your work areas are kept as secure as possible? Those are things that you should be thinking about. Okay, next we have wrath. And I think wrath, I'm going to show you here coming up an example of what not to do. What you don't want to do is to let your anger or your employees' anger drive the decisions that they're making.
I don't care. You know what, Tom? No, it's not harassment. Go right ahead. Leave. If anybody is not happy here, get the hell out of here. That's fine, Tom. That's fine. I have documentation and I have people around here. How much they cannot stand your ass?
Can I hear it from you people who can't stand me?
They won't talk to you, Tom.
It's on the message I was short.
No, because you're here.
The other one that did.
Exactly. Anybody have a problem with me here? Say it now. Say it now. You guys know how I am. Don't be opening your mouth anymore. I told you. Nothing is a joke with you. Nothing.
Call harassment.
Go right ahead and follow harassment charges. I have documentation on you.
Okay, so obviously I think we now see why this is not a good example for conduct for one of your employees. Hopefully your supervisors are not engaging in discourse in the same way that this individual who was, I believe, surreptitiously recorded was doing. Anger-based decisions often leave out very important procedural matters. Obviously, they elevate the discourse to a point that you wouldn't normally want or expect from your employees. I think it's very difficult for most people to respond to someone who's engaging in loud, verbally abusive language to not respond in like kind. So, this gets back to our discussion earlier about conduct policies and written policies and making sure your employees understand what's expected of them. So you don't want to deal with your employees from the perspective of anger. You also, and I think this is important because I've heard this before, and I've heard it more on the so-called campaign trail than I've actually heard it from some clients, although I have had clients call me and ask me some questions relating to this, and that is, you can't have an elected official who campaigns on the idea of, I'm going to come in and clean house. All of these employees who are there, they're not doing what we need them to do, and clearly we need to start anew, so everybody's going to be fired, and then we're going to hire all new people who are going to do a great job. Well, that's just not realistic. It's not realistic from the point of view of avoiding liability. And part of the reason for that is there's protections that apply to public employees who are hired, fired, promoted, demoted, etc., based upon political considerations. I mentioned this at the onset of our discussion today, and there is actually a United States Supreme Court decision that touches on this. In very few narrow circumstances, so if you have a high-ranking policy-making person, so say maybe a chief of staff, let's use the president for an example. The president can come in and can require that existing cabinet members leave, can hire his own chief of staff, can hire other high-level policy-making positions to suit his desires. But the lower level people, the people who are maybe even middle level, who are your career workers, who are there doing the dictates of the higher level policymakers, those people generally cannot be terminated or disciplined based purely on their political views without risking liability to the municipality. And even though that's true on a federal level, it's also true on a common level. So it's something to be aware of when you have newly elected officials come into a new position with your municipality. The First Amendment also protects free speech rights. I did touch on this earlier. As I indicated, employers, public employers included, do have a right to effectively run your municipality. And these employee rights are not unlimited, but you should be aware that they are protected when they are speaking out on a matter of public concern. The higher that they're ranked, the less job security they have, because those are considered to be policy-making decisions and policy-making positions. But also be aware that in addition to the First Amendment rights that protect some of what is going on with these employees, the Whistleblower Act also does that. So if they're alleging fraud, abuse, wrongdoing on the part of the municipality, be very careful in terminating them solely for doing that, for speaking out on that basis. And if you have questions about it, we generally recommend that you speak to a professional who can help guide you through those decisions. Another area where we sometimes see wrath or anger come into play, and this is what I mentioned earlier, and that is if you have an employee who has a property right in their employment. So there are certain employees who have property rights in their employment. Those are people who are covered by collective bargaining agreements. Those are people who might have been hired through or covered by civil service protection, or if you're a second-class township or a very small borough or first-class township without at least 3 police officers, you'd be covered under the Police Tenure Act. Those employees have protections before they are suspended, terminated, or demoted. And if you act in haste and terminate, demote, suspend without pay one of these individuals without according them their due process rights, you can face liability as an alleged violation of due process by the municipality. So you may have heard of the term a Loudermill meeting. That's an informal meeting for these employees who are covered under by collective bargaining agreements, or police officers or others who are covered under civil service. Before you terminate, suspend, demote them, what you need to do is to have a meeting where you identify to them what you believe they've done wrong, and you give them the opportunity to tell you their side of the story before you make a decision as to any discipline. That's what a Loudermill meeting is. That name comes from a United States Supreme Court decision. It was Loudermill versus Cleveland Board of Education. It's one that came out and since then has just really changed the landscape for public sector employment. You must do that before any disciplinary or termination action is taken in order to avoid a due process claim. So that's very important. Okay, next we have lust. What we're going to talk a little bit about under this so-called 7 deadly sin is failing to eradicate sexual harassment. And I think this is particularly important in today's hashtag #MeToo environment. We have Harvey Weinstein. We've seen other what were generally viewed as very prominent, powerful individuals, mostly men, who have fallen, Matt Lauer, who have fallen based upon allegations of sexual harassment. It's something that we see regularly in today's news cycle. So, of course, it's something to be very mindful of, aside from the fact that, of course, it's illegal for an employer to ignore and allow to continue harassment if they know that it's occurring. So next we're going to take a look at a brief clip of, again, what not to do. Hopefully you do not find yourselves in the same position that the following municipality found itself.
First, that breaking news out of Fraser tonight, where the city council voted to oust the mayor and the acting mayor.
Simon Chiquette is live in Fraser tonight with how this all unfolded. So, Simon, is centered around allegations of sexual harassment and misconduct.
That's right, Carolyn and Stephen. Very unusual hearing taking place right in there tonight with witnesses, a presiding judge, and in the end, the city's 2 top officials losing their jobs.
I'd like to make a motion to remove Mayor Joseph Nichols for official misconduct.
After a special tribunal held in Fraser tonight, members of City Council voting by majority to remove both Mayor Joe Nichols and Acting Mayor Matt Hemmelberg.
I am going to make a motion to remove Councilman Matthew Hemmelberg for official misconduct.
Votes coming after an independent investigation and testimony from witnesses alleging both men engaged in inappropriate sexual harassment on the job.
Mayor Nichols was still there, and at that time he was leaving. He came up to my desk and he began a conversation about how not everyone can wear leggings, but I could.
Lewd references to body parts.
I'd like to bag that one.
Yes.
Attorneys on both sides battling it out in what resembled a court hearing, complete with a retired circuit court judge presiding. However, certain evidence, including hearsay, was allowed since some normal court rules were not in effect. Also, council member Yvette Foster was the only witness called by defense.
One thing is to feel uncomfortable, but I don't think we have sufficient evidence.
You can see credible witnesses that didn't show up, but they still found, I mean, it's a bias.
I told you, spoiler alert, it's a non-biased trial. It was a kangaroo court. The reality is in there that we didn't get due process. The judge noted a couple of times, any other time the objections would have been sustained.
Council's attorney saying this was all allowed by city charter. However, both the mayor and acting mayor plan to fight this out in court. Stephen, back to you.
Yeah, the acting mayor said that witnesses didn't show up for their defense. Why didn't they?
Yeah.
So as we see, that's not the kind of press coverage that anyone would want for their municipality. We know that sexual harassment is a persistent problem. It's interesting to my colleagues and myself. We talk about this often. We provide training, we draft these policies, we talk to people in these types of forums regularly about this. And that's been going on literally for more than 20 years, because Title VII and the other laws that prohibit it. And it's just still here. It's as pervasive today as it was, when these laws came into effect. Title VII, of course, has been around since the 60s. Excuse me. And, therefore, I think the effort to try to get control of this issue remains important. It's clear that federal and state law both prohibit harassment on the basis of sex or gender. And that can come about in a couple of different ways. One is what's called quid pro quo sexual harassment. Generally, that occurs between people who have an imbalance in power in the workplace. You might have a supervisor and someone who's a subordinate employee, and the supervisor maybe is so explicit as to say, hey, look, if you do the sexual favor for me, I'll look kindly upon your application for a promotion. Or, hey, I know you really want this pay raise. If you'll sleep with me, or if you'll do whatever else it is that person has in mind, I'll ensure that your raise will happen. That's quid pro quo sexual harassment. The other type, and in fact, I think the more common type that we see is what's called hostile environment sexual harassment. That's where an employee or employees, or maybe even outside independent parties, engage in severe or pervasive conduct of a sexual nature that is unwelcome to the individual, that just makes things so bad for them that it has an impact on their ability to do their work in the workplace. So, the examples about this are, say if it's a lady, maybe she's one of the few or maybe the sole woman working in a police department, and all of the other male police officers continually hit on her, or they make comments about her appearance, or they catcall her, or whistle at her, you name it. And it's something that she is not okay with, and she lets you know. You obviously have an obligation to engage in an investigation, determine whether it's happening, and if it's happening, then you need to take corrective action on it. So, important to this analysis is making sure you have a policy, making sure that you've provided training, making sure that your employees know that you're not going to tolerate these types of things, and then ultimately showing them that if you find that it's actually occurring and you know that it's occurring, you're taking decisive corrective action to make sure that it stops. All right, next we have gluttony. What this has to do with is misunderstanding actual versus perceived medical conditions and taking appropriate action to address them. This is an area that I will say is rife with problems. It's rife with misunderstandings. It's very complicated oftentimes for employers to enforce. When we start talking about disabilities and employees with disabilities and what that means, what does it mean whether someone's a qualified individual with a disability, what does it mean I have to engage in the interactive process, etc. We're going to talk about those things so that you at least have a very basic understanding of what that means. But next, again, cautionary tale, do not be the employee that we see coming up. And if you have these employees, it'd be great if you have an employee like this, it'd be great to get them on camera in the same way that we'll see here.
Tonight, a contestant on The Price is Right. The problem is she had told work she was injured. This evening, how she's spinning this now to ABC's Cecilia Vega.
It's The Price is Right! When you hear those three famous words on The Price is Right, oh, come on now! You do what the man tells you, fast, like this woman, Kathy Cashwell. $1,375. But a fortune and fabulous prizes wasn't the only thing Cashwell was collecting. Cashwell was also cashing in $3,000 a month in workers' comp, claiming an on-the-job shoulder injury left her totally unable to stand, run, reach, or grasp.
Here we go, good luck.
But there she is, spinning that big, heavy wheel, not once, but twice. It turns out The Price is Right double dealer isn't the only one.
Okay, so, obviously we have, it's not often that you have an example of someone engaging in workers' compensation fraud that's broadcast on national television. I can tell you, though, that there have been times where I've helped employers through, say, workers' comp fraud, where the one that I remember very clearly was a police officer who had claimed to not be able to work at all due to a back injury, who claimed to not be able to work at all due to a back injury, had been off work for some period of time. The workers' comp carrier had approved a private detective to take a look at their claim and caught them on video at a horse show, lifting very heavy bales of hay, manipulating them in such a way that it would have been very contrary to the injury that they claimed to have had, and putting them on the bed of their truck. So, you know, these things do happen. And unfortunately, it makes it difficult sometimes, I think, for employees who do have legitimate need for accommodation or need to be off work. And, you know, what we're going to talk a little bit now are those individuals who might be subject to protection of the Americans with Disabilities Act. Basically what this is, it's a federal law that prohibits employers from discriminating against qualified individuals with a disability in regard to hiring, firing, in all terms and conditions of employment. I would note that that includes in the application process. It's a requirement that employers try to accommodate individuals. Now, there's several things to unpack here. What is a qualified individual with a disability? That's a term that's used in the law. And basically what that means is that the individual who's applying for a position needs to be able to actually do the essential functions of the position. Well, what are essential functions? Essential functions are those things that are inherent to that position that make that job what it is. So we all know that with most jobs, there might be some ancillary duties that an employee has to do. But let's use a firefighter, for example. Firefighters do a lot of different things in the scope of being a firefighter. But ultimately, what they need to be able to do is when called upon, they need to be able to go fight fires. They need to be able to get in the truck. They need to be able to go out. If they have to break through an area to get in there to fight the fire, they need to know fire protection techniques, etc. If they can't do those things, well, then they can't be a firefighter. Similarly, the analysis is you're a qualified individual with a disability if you can do those things that are inherent to that position. And if you can't, then you may not be subject to the protection of the ADA. It's also very important to know that those individuals who are qualified and have a disability might be allowed or subject to a reasonable accommodation in some portion of their work. What does that mean? In order for that to occur, the employer needs to engage in what is called an interactive discussion with the employee. An interactive discussion is just how it sounds. If they come to you and they say, I have a medical condition and I need to change something in my work environment, that should be enough to key you in on the idea that this person might need to be accommodated in some way. It's not required, and the law is very clear on this, they're not required to use any certain term. There's no magical way that they have to ask you. They just have to say, I'm dealing with a medical condition that's making it difficult for me to do a certain part of or all of my job, and that should trigger in you the idea that, well, I need to talk with this person to see what that means. Employers have tools at their disposal. You can ask, if it's not obvious that someone has a disability, you can ask for them to provide medical documentation supporting their claim. If they ask for a certain accommodation, which should be, as I said, an interactive discussion, you can ask them to provide documentation to support their need for that accommodation. It also doesn't mean that you have to provide exactly what they're asking for. If there's an alternative, effective accommodation that is less burdensome for the employer to provide, well, then you can propose that. And that would satisfy your obligations under the ADA. Please note, I'm oversimplifying. This process can be lengthy. It requires patience. You do have tools available to you. And I would say if you're having questions about either a request for accommodation or a specific type of accommodation that's being requested, or changes in a workplace or changes in a work environment, and whether those are reasonable, please seek help. There are trained professionals, lawyers who practice in this area, like myself, who can help guide you through what can be a very frustrating process. I will also note, this is very important, we see a lot of liability issues come up from this. Job interviewers need to be trained to know what they can and can't ask. And I would note that I would include among those people elected officials. It's not always the case that elected officials participate in an interview for an employee of the municipality. But if they do, please make sure that they at least have gone through some sort of minimal training so that they know what they can and can't ask. Elected officials come from all walks of life. Some of them may have never had to have dealt with that particular issue. And because of that, we've seen some questions asked that should have never been asked that have created liability for municipalities. So that's one thing that we often recommend. Contrary to what I said before, I said before that you will often hear employment attorneys like me say consistency is key, and that is true in almost every area. It's certainly true in the application of your policies. Where it's not is in an ADA context, where someone is asking for an accommodation and they're providing documentation to support the need for whatever accommodation it is. You have to, the law requires that you treat that on a case-by-case basis, because no two individuals are exactly alike, and no two individuals have exactly the same manifestation of problems relating to, even if two people say are diabetic. One might have issues that the other one doesn't, and vice versa. So under the ADA analysis, you need to look at what the individual's condition is, what the requested accommodation is, what their job is, because that's often key to what a reasonable accommodation might be. So there's no one-size-fits-all solution, and we want you to be aware of that. A couple other areas of liability that often come up. It's important to know that accommodations can mean a number of things. It can mean adjusting a height of someone's desk. It can mean allowing them to turn the lights off for certain periods of time because maybe they have sensitivity to light, or maybe being able to go into an area that's secluded where they have privacy to administer some type of medication to themselves, maybe with a shot or some other means. It can also mean taking time off without pay. The EEOC, which is the federal agency that enforces the ADA, takes a very strong position that unpaid time off can constitute a reasonable accommodation. Flex time, changing the starting or ending time, changing lunch periods, maybe they have a set lunch period. All of those things are things that could potentially be a reasonable accommodation. The key is it can't create an undue hardship for the employer. Undue hardship can mean money, it can mean administrative burden, but it has to be real. And if you've ever offered a change in the workplace, the work environment, change in schedule for another reason that's not related to the ADA, it makes it very difficult for you to say, well, because this person is disabled, I can't do it. They will point to those other examples, and I will tell you that if they file an EEOC case, the EEOC will look very unkindly upon your differentiation. Another particular area of problem that we see with employers is sometimes they'll have a policy, say for instance an FMLA policy, that explicitly says if you can't come back after your 12 weeks of leave, you're done, you're fired, you're terminated. Well, you can't be that inflexible. If someone comes back and say they're a week out from their 12 weeks max and they say, look, I know this is what our policy says, I'm having some issues and I can't come back right at 12 weeks, but I can come back in 2 weeks after that, you should engage in that interactive process and have a very serious conversation with them about whether you should allow that. Because ultimately, the EEOC again takes a position that if it's a finite period of time and it is not going to create an undue hardship for the employer, and again, it has to be a real undue hardship, not one that's imagined or just stated, then you may need to consider allowing that accommodation. Now, if they come back to you and say, I have no idea when I'm going to be able to come back, my doctor has no idea, that's different. Indefinite leave is not a reasonable accommodation. So just please be aware that even if you have a policy that says that, it doesn't get you out of the woods if you have a request for accommodation come your way in the way that I've just described. Next, we have greed. This is a frequently litigated area. What I'm going to turn to is one of our most famous cinematic representations of this sin.
The new law of evolution in corporate America seems to be survival of the unfittest. Well, in my book, you either do it right or you get eliminated. In the last 7 deals that I've been involved with, there were 2.5 million stockholders who have made a pre-tax profit of $12 billion. Thank you. I am not a destroyer of companies. I am a liberator of them. The point is, ladies and gentlemen, that greed, for lack of a better word, is good. Greed is right. Greed works. Greed clarifies, cuts through, and captures the essence of the evolutionary spirit. Greed in all of its forms. Greed for life, for money, for love, knowledge, has marked the upward surge of mankind, and greed, you mark my words, will not only save Teldar paper, but that other malfunctioning corporation called the USA. Thank you very much.
Okay, there's good old Gordon Gekko. The area that this arises in is failing to recognize and address poor pay practices. There's a federal law, it's called the Fair Labor Standards Act, that dictates or mandates how individuals are paid and whether they're entitled to overtime. And, you know, I think we all, at least from a general perspective or a visceral perspective, are aware of, you know, some people are paid a salary, some people are paid a wage meaning that they're generally paid by the hour. It's a lot more complicated than that. And in fact, this is an area where a lot of employers get into trouble. One of the things that we try to dispel the notion of everywhere we go is just because someone is paid a salary doesn't mean that they're exempt under the Fair Labor Standards Act from being paid overtime. It's clear under the Fair Labor Standards Act that there are certain jobs that can be paid a salary without mandating overtime payment. And there are other jobs that, regardless of how they're paid, the focus is on what they do. And there are 3 exemptions under the Fair Labor Standards Act, generally that might apply and make someone exempt from those overtime requirements. But a failure to look at your pay practices, a failure to make sure that they're being made in compliance with the Fair Labor Standards Act, a failure to evaluate who's being paid on a salary basis and whether they actually should be paid on that basis, those are areas where you can run into trouble. So what we often recommend is, you know, if you have questions about it, you know, you can do what's called an audit, where you look at what are they being paid, how are they being paid, and more importantly, what are they actually doing for you to determine whether you might need to change the manner in which individuals are paid. The other thing that I think it's important to mention is that, you know, we're all generally aware that if an employee works more than 40 hours a week, and if they're a non-exempt employee, in other words, they're required to be paid overtime, if they work more than 40 hours in a week, then they're required to be paid overtime, which generally equates to time and a half, their base rate. Well, there are a lot of collective bargaining agreements that dictate that even though that's true as a matter of law, your collective bargaining agreement might say either 40 hours in a work week or 8 hours in a day. And if that's the case, then you need to obviously follow your collective bargaining agreement. The other thing some people don't know is that 40-hour work week doesn't apply to all classes of employees. So if you have police officers, for example, police officers are non-exempt employees, at least your regular patrol officer, and an employer can negotiate with them a pay period that would require them to not be paid overtime until they've worked 43 hours in a week. And that's something that maybe a lot of people don't know. Now, you can't just start doing that if you have a collective bargaining agreement that says otherwise. You have to follow your collective bargaining agreement, but it's something that you can put on your list of things to bargain for the next time you enter into negotiations. Similarly, if you have paid firefighters, it's an even higher threshold. What it works out to for firefighters is if you can negotiate with them to say that you're going to define a work period in a way other than the 40-hour work period, you can require, and the Fair Labor Standards Act allows this, up to 53 hours of work by a firefighter before they're required to be paid overtime. So it's, and of course that can create quite a cost savings to the municipality. So these are things that I think you should be aware of as you work through these pay issues with your employees. I mentioned the fact that you have to follow your collective bargaining agreements. The other area that often comes up and can become a problem for public sector employers is comp time, compensatory time. That is time granted at time and a half to an employee in lieu of overtime pay. And there are limits on the amount of time that can be granted depending upon the type of employee that you have. Well, the problem with comp time, it was designed to cut down on overtime pay, but unfortunately it often has the reverse effect where it creates more problems because it can be very tough to manage. And if it's not managed well, it can create overtime on overtime, which of course many of your budgets likely aren't supporting. So it's something to be aware of. We can help you get a hold of these problems. Oftentimes, collective bargaining agreements dictate how the comp time can be used and when it can be used, etc. What you want to make sure of is that your collective bargaining agreements, if they have those, or your policies, if you're dealing in a non-union environment, allow the employer the leeway that the law allows to mandate that use in a way that doesn't create more overtime responsibilities for the employer. Finally, I just wanted to touch very briefly on insurance and risk management. I think it's very important to know, and I mentioned this earlier, you can and should have employment practice liability coverage, which would help you defend and hopefully pay for some claims if they come down under some of the theories we've talked about today. As I mentioned, you cannot purchase coverage for punitive damages. You can't purchase coverage for intentional acts. Those things are outside the boundaries of what are insurable. It's also important, if you're dealing with an insurance broker, to deal with someone who is used to working with municipal entities. Local governments are a unique animal in the insurance world, and if you're not working with a broker who understands that that's true, it can create less value for what you're getting from your insurance carrier. So we often recommend work with those who have actually worked with municipal entities before so that they understand some of these risks that are not inherent to a private sector employment environment. So with that, I think we're close to the end of our time. I wanted to ask if anybody had any questions. I'm happy to answer them. I would also note, if there are no questions, on the materials you can find the contact information both for our Pittsburgh office and also for our Philadelphia office. Whichever one you're closer to or you prefer, you're welcome to contact us if you have any questions. I'd be happy to answer those for you. I appreciate your time today.
And Shon, there was one that came in through email. It's more of a scenario. It seems pretty specific, so if you don't want to answer it and give specific legal advice, we completely understand, but we thank you for taking your time today. Okay, so the public works supervisor hires their son as an unofficial, unpaid intern working alongside the road crew in hopes of snagging the first job opening when it's available. What are the liabilities for the employer, aka municipality?
All right, well, that one's packed full of potential liability issues, not the least of which is there are Fair Labor Standards Act requirements that apply in the hiring of an intern. Now, I will note that those requirements for hiring an intern who is unpaid do vary between private sector and public sector. And the conventional wisdom among the private sector anymore is that you cannot hire an unpaid intern. It is a little bit different in the public sector. I would urge you to talk with your labor counsel about that. But the other issue is having a quote-unquote intern on the job who maybe hasn't been sufficiently trained, who maybe isn't physically fit to do the job. I don't know the situation. The point is, if they're acting under the auspices of the local municipality, and we know that and allow it to happen, what do we do if they're injured on the job? Do we now have a workers' comp issue? What do we do if they're operating in a way that creates harm or damage to either another person or to other person's property? Are we responsible for it? I think the answer to most of those things are, well, we very well might be. The other thing is, to me, this is a matter of poor judgment for that public works supervisor. I expect that this is not something that the municipality wanted to happen. It may even be in violation of the nepotism policy if you have one. To me, it would mandate a pretty serious conversation with this public works supervisor about what their thought process is as they went through the decision to hire their relation. Does it create issues under your collective bargaining agreement? Potentially it does. So there are a lot of risks that I see in that happening. You know, I don't want to engage in real specific advice without, you know, engaging in an attorney-client situation. But there are serious risks. I think the fact that you asked that question shows that you're thinking of these things the right way. I would urge you to talk with your solicitor or your labor counsel about it to work through those issues. Thank you for the question.
All right, yeah, that was the only one that came in via email. We do thank you so much for your time. Obviously, the K in Shon K. Warner stands for knowledgeable, and it sounds like you could have went on for another hour or two. So, again, we thank you so much for your time. On behalf of Local Government Academy staff and Board of Directors, we want to thank everybody for joining us today. And tune in again next time. Stay tuned with our newsletter to find out when our next events are coming up. And thanks again for joining us. Thank you, Shon.
Thank you.